Now we will discuss about the Articles of Association. Articles of Association are the second document which has to be registered along with the Memorandum of Articles of Association of a company in case of some companies. Companies which must have Articles of Association are unlimited companies, companies limited by guarantee, and private companies limited by shares. This document contains rules, regulation and bylaws for the general administration of the company. They may be prescribed as the internal regulation of the company, governing its management, embodying the powers of the directors and officers of the company as well as the powers of the shareholders. They lay down the mode and the manner in which the business of a company is to be conducted. In framing of Articles of Association, a care must be taken to see that regulations framed do not go beyond the powers of the company itself and as contemplated by the Memorandum of Association, and nor should they be such as would violate any of the requirements of the Companies Act itself. All clauses in the articles ultra vires the memorandum or the act shall be null and void. Now we will discuss about the contents of Articles of Association. Articles generally contain provisions relating to the following matters. First, share capital, different classes of shares of the shareholders and variation of their rights. Second, allotment of shares. Third, calls on shares. Fourth, issue of shares certificate. Fifth, issue of share warrants. Sixth, transfer of shares. Seventh, transmission of shares. Eighth, alteration of share capital. Ninth, borrowing powers of the company. 10th, rules regarding meetings. 11th, voting rights of the member. 12th, accounts and audit. 13th, directors, their appointments and remuneration. 14th, payment interest of the capital. 15th, common seal, and 16th, winding up of a company. According to Section 5 of the Companies Act 2013, articles of a company contain the regulations for management of a company. They contain prescribed content, but additional content may be added if necessary for management of a company. The articles may provide for entrenchment, which means that entrenched regulations or entrenched clauses of articles can be altered only under conditions which are more restrictive than the special resolutions, which is generally required for alteration of articles. Provisions for entrenchment may be made at the time of formation of a company or later on by an ordinary resolution in case of a private company and by special resolution in the case of a public company. Now, how can alteration of articles of a company be done? Section 31 of the Companies Act 1956 grants power to every company to alter its articles whenever it desires by passing a special resolution and filing a copy of altered articles with the registrar. In case of a conversion of a public company into a private company, alteration in the articles would only be effective after the approval of the central government. The power is now vested with the registrar of companies. Alteration of articles shall not violate provisions of the memorandum. It must be made on the bona fide for the benefit of a company. Alteration must not contain anything illegal and shall not constitute fraud on the minority. Alteration in the articles increasing the liability of the members can be done only with the consent of the members according to the Section 31 of the Companies Act. After passing a special resolution for altering the articles of a company, an alteration is approved by the central government. The company is required to submit a printed copy of articles so altered to the registrar of companies within 1 month of the date of the passing of a special resolution. Now, how an alteration of association of articles of association can be done under the Companies Act 2013. The Companies Act 2013 lays down that according to the provisions of this Act and the conditions contained in the memorandum of a company can alter its articles by special resolution. Every alteration of articles under section 14 of the Companies Act 2013 and a copy of the order of the tribunal approving the alteration shall be filed with the registrar, together with the printed copy of the altered articles. The 2013 Act lays down that a very important point regarding alteration of articles of a company. It says that any alteration of articles of a company according to the subsection 2 of section 14 should be valid only when it is originally present in the articles. Now, just let's also talk about briefly the importance of articles of association also. The articles of association are the next importance to the memorandum of association. While the memorandum of association lays down the objects or purposes for which a company is formed, the articles of association prescribes the rule and regulation for the attainment of the objects contained in the memorandum of association. The articles of association provide the rules and regulations for the internal management or the day-to-day administration of the company and embody the powers of the directors and officers of the company as well as the right and duties of the shareholders and the members of the company. They also regulate the relationship between the company and its employees, between the company and its members, and between the members themselves. Now, after looking at the importance of both memorandum and articles of the association, let's just start discussing about distinction between the articles and memorandum. Memorandum, first distinction is, first, it is a charter of a company which indicates the nature of its business and capital. It also defines the company's relationship with the outside world, whereas articles are regulations for the internal management of the company. Second distinction, memorandum defines the scope of the activities of the company or the area beyond which the actions of the company cannot be taken, whereas articles, they are the rules for carrying out the objects of the company as set out in the memorandum. Third distinction is memorandum, it being the charter of the company is the supreme document, whereas articles, they are subordinate to the memorandum. If there is a conflict between memorandum of the company and articles of the company, then the provisions of the memorandum will prevail over articles. Fourth distinction is memorandum, every company must have its own memorandum, whereas articles, now under the Companies Act, it is necessary for all types of companies to have articles. Fifth distinction is any act of the company which is ultra vires, the memorandum is wholly void and cannot be ratified even by the whole body of shareholders, whereas under articles, any of the act of the company which is the ultra vires, the articles can be confirmed by the shareholders if it is intra vires the memorandum. Now we will talk about the doctrine of constructive notice. What do we mean by the doctrine of constructive notice? Every person dealing with the company is deemed to have a constructive notice of the contents of the memorandum and articles of the company. A person is expected to inspect the basic document of the company, which are memorandum and articles, and they are available at the office of the registrar of a company. An outsider dealing with the company is presumed to have read the contents of the registered documents of the company. The further presumption is that he has not only read and inspected the documents but also have understood them fully in the proper sense. So, the doctrine of rule of constructive notice is a presumption operating in favor of the companies against the outsider. Now, we will talk about the doctrine of indoor management. This doctrine is an exception to the doctrine of constructive notice. This doctrine has been applied to many companies liable in case where the deal are made by the directors. First, whose appointment was defective. Second, who were appointed properly but were yet to be delegated necessary authority. Thirdly, who had not yet been appointed as directors. Fourthly, who have been delegated authority in a meeting which had been lacked quorum. There are some exceptions to this doctrine of indoor management. Though the doctrine provides outsiders protection while dealing with registered companies, court in the case of Royal British Bank versus Turquent did not find it proper to apply the doctrine in following cases, and the protection was denied. The first exception is knowledge of irregularity. When a person dealing with a company has actual or constructive notice of the irregularity as regards internal management, then he cannot claim the benefit under the rule of indoor management. He may in some cases be himself be a part of the internal procedure. Second exception is negligence, where a person dealing with a company could discover the irregularity if he had made proper inquiries. He cannot claim the benefit of the rule of indoor management. The protection of the rule is not available where the circumstances surrounding the contract are so suspicious as to invite inquiry, and the outsider dealing with the company does not make proper inquiry. Third is forgery. Fourth is act outside the scope of apparent authority. If an officer of a company enters into a contract with a third party, and if the act of the officer is beyond the scope of his authority, the company is not bound.